laws in Indian commercial law. Without Contract Act, it will be very difficult to carry on any trade or any other business activity. The Contract Act, in fact, has an effect on every one of us. There are different definitions for a contract. According to Pollack, every agreement and promise enforceable by law is a contract. Salmond defines a contract as an agreement creating and defining obligations between parties. Section 2 of Indian Contract Act 1872 defines contract as an agreement enforceable by law is a contract. Therefore, agreements which are not enforceable by law are not contracts. An agreement means a promise or a set of promises forming consideration for each other. And a promise arises when a proposal is accepted. By implication, an agreement is an accepted proposal. In other words, an agreement consists of an offer and its acceptance. An offer is the starting point in the process of making an agreement. Every agreement begins with one party making an offer to sell something or to provide a service. When one person signifies to another his willingness to do or to abstain from doing anything with a view of obtaining the assent of the other to such an act or abstinence, he is said to make a proposal. For example, A wants to sell his car for rupees 5 lakhs. B offers to buy A's car for rupees 5 lakhs. Now B has made an offer to A to purchase his car. An agreement emerges from the acceptance of the offer. Therefore, acceptance is the second stage of completing a contract. As per Section 2B of the Indian Contract Act 1872, when the person to whom the proposal has been made signifies his assent thereto, the offer is said to be accepted. Thus, the proposal when accepted becomes a promise. In the example, B offers to buy A's car for rupees 5 lakhs and A accepts such an offer. Now, this has become a promise. When the proposal is accepted, it becomes a promise and it also becomes irrevocable. An offer does not create any legal obligation, but after the offer is accepted, it becomes a promise, and a promise is irrevocable because it creates legal obligations between parties. An offer can be revoked, but before it is accepted. Once acceptance is communicated, it cannot be revoked or withdrawn. An agreement is a contract if it is made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and is not expressly declared to be void. The contract must be definite. Its purpose should be to create a legal relationship. The parties to the contract must have the legal capacity to make it. According to the Contract Act, every person is competent to contract who is of the age of majority and who is of a sound mind and is not disqualified from contracting by any law to which he is subject. Thus, minors, persons of unsound mind, and persons disqualified from contracting by any law are incompetent to contract. In the above car sale example, both A and B have legal capacity to enter into a binding contract. That is, both are major with sound mind and are not disqualified by any law. Consideration simply means that both the contracting parties are bound to give something of value to each other. Mutual and lawful consideration for agreement is essential for a contract to be enforceable by law. Hence, intention should be to create legal relationship. Agreements of social and domestic nature are not contracts. Going back to the car sale example, the car itself and rupees 5 lakhs are mutual considerations in that contract. Let us now look at specific performance. As we spoke earlier, a promise is irrevocable because it creates legal obligations between parties. An offer can be revoked but before it is accepted. But once acceptance is communicated, it cannot be revoked or withdrawn. Consent is a very important part of the contract. The contract becomes void if there is any misrepresentation, mistake, or fraud. In case of a breach of a contract, specific performance is granted depending on the situation. If the general essential ingredients of a contract are fulfilled, a valid legal contract is formed and it becomes effective from the date it is accepted. In the car example, B made an offer and A accepted the offer. Once it is accepted, it becomes a legally binding contract. A cannot refuse to sell the car to B. B can approach the court for specific performance of the contract. Now the question arises, is it essential to have an agreement in writing? There is nothing in section 10 dealing with the essential requirements of a valid contract to show that writing is a necessary condition for the validity and enforceability of a contract. Therefore, unless warranted by a specific law, it is not necessary to convert agreements into writing. A meeting of minds or identity of the will of the parties in full and final agreement is considered the essence of a contract. There must be consensus ad idem. In the car example, A possesses two cars, yellow and white. A intends to sell the white car, but B assumes that A is selling the yellow car and made the offer to buy the yellow car. There is no consensus ad idem here. Therefore, this contract becomes voidable. In summary, the essentials of a valid contract includes offer and acceptance, free consent of parties, competency of parties, lawful consideration, lawful object, and it should not be declared as void.